Hi, I'm Paul Mallis, partner in the law firm of Young, Marr, Mallis and Associates. Welcome to the Paul Squared podcast. I started my career in the district attorney's office, and in 2016, I turned my focus to exclusively defending clients charged with crimes. I created this podcast to provide an overview of the criminal law process and to answer the questions I most often get when I first meet prospective clients. My goal is to protect my clients' rights and to guide them through the stressful process of being charged with a crime. While this podcast serves to provide general guidelines around the practice areas we discuss, you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the applicable laws. The decision of choosing an attorney is an important one, and you should give it careful thought before deciding. If you need representation or just have questions, please don't hesitate to contact me at 215-639-5297, or you can visit our law firm's website at www.ykacrim.com. That's ykacrim.com.
We're back with Paul Mallis, and we're going to be talking about other typical criminal charges. This is the last episode in this particular series, and we wanted to use this episode to sort of talk about some criminal charges that Paul typically sees people come into his office with so that we cover some of those frequently asked questions. So, Paul, welcome back.
Thank you for having me.
So, what we wanted to do with this last episode, we talked about DUI charges, which is, kind of a fairly common criminal charge that you see that you defend clients with. But we wanted to make sure we hit some of the other bigger ones that people come to you often for. And I think we've talked in previous episodes about, what it means to be charged with a serious crime in Pennsylvania and how this impacts someone's record and shy of an expungement that it's going to hang around. So what we wanted to sort of get into on this last episode is specifically some areas of criminal charges that you see pretty often. So we're going to start with drug crimes, because I think that's something that unfortunately we all see a lot more and hear about that are out there. And so there's some particular elements to this that wanted to discuss. So first of all, when we talk about drug crimes, what generally speaking are we talking about that you see in terms of crimes that involve drugs?
The whole gambit, from the drug user, drug abuser, to the drug dealer, to the empire drug organization that's on the corner of the street. So we really see the whole gambit of drug cases now.
And I know one of the ones that is fairly common is possession, and you have different layers and levels of possession, but one of them is called simple or personal possession. So can you explain what that is and how that typically comes about?
Simple possession is the guy that had a bag of heroin on his person, or the kid that had, a few grams of pot in his dorm room. Simple possession is the guy that went out partying that had a bag of cocaine on his person. That's simple possession is the person that's using the drug recreationally, that's using the drug to feed his or her own habit. They're not distributing the drug. They're possessing it for their own personal use purposes.
And then when we get into the next sort of level, which is possession with intent to distribute, first of all, can you explain what that is, and then just sort of get into what's the difference between simple possession and possession with intent to distribute?
Sure. Possession with intent to distribute is a felony crime. It's much more serious than simple possession. We call it PWID for short, possession with intent to distribute, or possession with intent to deliver. That's the type of situation where there's actual hand-to-hand delivery. There are drug transactions that are taking place, where a person is selling drugs, or it's the type of situation where the person is selling drugs, but there's no actual delivery. What the charge is based on is the amount of drugs, the type of drugs, the packaging of drugs, and other types of paraphernalia that the client might have on his or her own person to show that these drugs were really possessed with the intent to distribute. They weren't for personal use.
So I would imagine a big difference, you can have an ounce of pot per se on your person. It's sitting in one baggie. That looks very different than you have an ounce of pot and it's broken up into
Right.
10 small baggies.
The guy with an ounce of pot in one big bag. It's the Costco argument. They're buying in bulk to provide continuity to their usage. They're versus the guy that has small 1 inch Ziploc bags and a scale sitting next to it, who probably isn't using that for his or her own personal use.
And so do you find, obviously, what do you think are the biggest factors? Obviously, we just described how the actual possession, what kind of containers they're in, can certainly go to the difference between possession and distribution. Do the type of drugs influence that much?
Yeah, definitely. When police are making a decision on whether to charge simple possession or possession with the intent to distribute, and there's no actual hand-to-hand transactions, they look to certain factors. They look to the type of drug involved. They look to the quantity of drug involved. They look to how the drugs are packaged. They look to whether or not there's cash involved or drug transaction sheets. They look to whether firearms are involved. They look to a multitude of different factors that, based on that police officer's experience as a narcotics officer, as a narcotics expert, they can render an expert opinion that these drugs, they were possessed with the intent to distribute.
So it's the totality of all those things that sort of go into whether they were
Right,
looking for that charge or not.
right, right. They look to all of the circumstances, the totality of circumstances in rendering an opinion whether the drugs were possessed for personal use or possession with intent to deliver.
So I think most people have heard the word trafficking then too. So what's the difference, or what is trafficking as compared to distributing? Is there a difference between the two?
Not really. Trafficking is synonymous with delivery. You're trafficking drugs or you're delivering drugs. The two terms are synonymous with one another. If you're trafficking drugs or you're delivering drugs, you're going to be charged with possession with intent to distribute in Pennsylvania.
So why do they have different names for them, or it's just, is there any nuances that really make much of a difference?
No, really not. They are synonymous with one another. Trafficking and delivery.
Okay. And then as it relates to marijuana, with now the ability for someone to have a medical marijuana card, um, does having a medical marijuana card automatically get you the get out of jail free card with no matter how much marijuana you have on you, or how it's packaged, or any of these other things that we just talked about?
We don't like to speak in terms of absolute or guarantees. So to say that a medical marijuana card automatically absolves you of criminal culpability would be an overstatement, I'd say.
Yeah.
The Medical Marijuana Act really, if you have a valid prescription for medical marijuana, then that marijuana has to be contained in the same packaging material that it was purchased in pursuant to that valid prescription. And if it is under that set of circumstances, then the quantity really doesn't matter because it's you have it pursuant to a valid prescription.
So as long as it's contained within the original packaging as you would have purchased it at one of the distributors or dispensaries, I'm sorry, that is going to be the defining factor of whether or not somebody's going to look at possession of marijuana on your person and say you have this legally or not pursuant to that prescription card.
It's going to be a motivating factor. I don't know if it'll be a controlling one or a defining one, but it'll be a motivating factor. Certainly, there are individuals with a medical marijuana card that are going to purchase the marijuana lawfully, but they might not possess it lawfully. They might be purchasing it lawfully and then selling it unlawfully. So I think depending on the packaging, that might be a motivating factor as to whether or not the drugs were possessed validly and lawfully.
Gotcha. And can you just talk in generalities about some of the potential consequences of being charged with a drug crime? I'm sure some drugs are considered, to be higher level offenses than others. Quantity and those different pieces are going to certainly play into it. But, just in general, can you talk about how the courts seem to be, or DA's offices seem to be viewing drug crimes?
The guy that's delivering fentanyl and cocaine is going to be sentenced differently than the guy that's delivering marijuana. We talked about sentencing guidelines that judges use in fashioning an appropriate sentence. And we talked about what's called the offense gravity score, which is really the nature of the offense that was committed, shoplifting or first-degree homicide. If we're talking about drug delivery, we further break that down into the type of drug involved and the quantity of that drug that was involved. And depending on the type of drug and the quantity, that will drive the sentencing guidelines upwards or downwards. It's based on those two things.
So from your experience, at least now, what do you see are the types of drugs that are getting the strictest scrutiny in terms of charges?
Look, with the heroin epidemic is ruining this country by and large. I could really speak to in and around the Philadelphia County. Judges are coming down with very, very harsh sentences for heroin fentanyl dealers. A message is being sent on the streets that if you sell heroin, you are going to be sentenced very, very harshly. So that's typically what we see. A message is being sent, and very, very harsh penalties are being handed down. Now, that's different than the drug user, the heroin user who's selling heroin or fentanyl to support his or her own habit, versus the drug dealer who's dealing strictly to make profits. The drug user who's dealing to support his or her own habit, albeit selling heroin, that person is going to be sentenced differently than the person who's in it for the profits.
So someone with an addiction that's going to come into play as to, what their intentions are and why they're doing what they're doing.
Certainly, absolutely. They might be violating the drug delivery statute, violating the law, but the circumstances, the nature and circumstances under which they've committed their crime, that's going to be taken into consideration by a sentencing judge.
Gotcha. So next turn our attention towards a category that's called violent crimes. And in particular, we're going to focus on a few types of crimes that you see regularly charged under violent crime statutes. I guess, first of all, can you talk in generality what a violent crime is in Pennsylvania?
Sure. A violent crime could be assault, it could be robbery, it could be a sex offense, rape, indecent assault, aggravated indecent assault, murder. Really, a physical type offense would be a crime of violence. Domestic assault, domestic violence, those types of crimes we're talking about. What we're not talking about are DUIs or shoplifting offenses.
So this is typically more of a physical type crime where someone is physically hurt in some way, shape, or form. Okay.
Right.
So, and I know there's a homicide and manslaughter and other kind of charges like that fall underneath this, but I think those are less common than other charges that you see more regularly. So we're going to focus on ones that you've indicated you see come through your doorway more often than others. So the first one we want to talk about is assault. Can you explain what assault is?
Sure. Assault really is committing some sort of a bodily injury against another person. That's really, in basic terms, what an assault is. Either you've caused bodily injury, or you're attempting to cause bodily injury. And that's really what we call a simple assault, bodily injury, bruising, substantial pain, discomfort, and you're doing so with the intent to cause that type of injury, versus what we call aggravated assault. Aggravated assault is a felony, and we're looking at an increased type of violence. We're looking at what's called serious bodily injury, protracted injury, protracted loss of life, broken bones, missing limbs. That type of an injury would rise to the level of aggravated assault.
And using a weapon, could that take something from simple to aggravated?
It could. Using a weapon could elevate or escalate the crime from what otherwise would have been a simple assault to an aggravated assault with a deadly weapon, and that would escalate the offense from a misdemeanor type offense to a felony of the second degree.
So is a simple assault typically a misdemeanor, and a aggravated assault is a felony charge?
Yes. So typically we see simple assault offenses graded as either a misdemeanor of the second degree or a misdemeanor of the third degree, depending on whether or not depending on the circumstances, whether or not it was a mutual type fight or whether or not it was a one-sided unilateral fight. Versus aggravated assault, that's going to be a felony. You're looking at felony type offenses with aggravated assaults.
So would it be a fair maybe example be, hey, two guys get in a bar fight, they bloody each other's noses, and they go home. That's simple assault for each of them potentially.
Depending on the exact set of circumstances, but typically we see the bar fight usually as a simple assault type offense.
But if that same bar fight escalates, somebody picks up a pull stick and whacks the other one in the head and still stomps on them while they're unconscious, you're now getting into aggravated assault.
And potentially worse. You could be getting into attempted homicide at that point, intent to kill. I mean, if you're using when deadly weapons, a deadly weapon is broadly defined. It can be any type of object that's used or designed to be used to kill. And so a pool stick, in that regard, depending on how it's used, that could be used as a deadly weapon and could escalate it from aggravated assault to an attempt to commit homicide.
Gotcha. And then the next sort of category I want to get into, and I don't think these are violent crimes per se, or maybe they do. Robbery, burglary, and theft. They all, I think, to the average layperson, sound like the same thing. I guess first of all, are these considered violent crimes, or are they in their own category?
No, they are. I mean, robbery and burglary are crimes of violence by definition. Theft, depending on the circumstances, it may or may not rise to the level of crime of violence, but certainly robbery and burglary are. But they really are mutually distinct offenses. Theft could be considered as a lesser included offense, or it could fall within the robbery type umbrella. When we're talking about a robbery and we're talking about the elements of a robbery offense, we're saying that in the course of committing a theft, an injury occurred. Right?
Okay.
Or a threat to commit an injury occurred. And that's really what we're talking about with robbery. We would call it theft plus. Versus a burglary is really talking about the breaking into or the entering into of a home or a car or your place of employment. And you're doing so with the intent to commit a theft.
So robbery is robbing someone's person, versus burglary is burglaring or committing a theft inside someone's place. And theft could just be that it's a piece of either one of those, or you swipe something off the candy counter type of deal, and that's its lesser offense.
Look, you could be charged with robbery if you're entering into someone's home. It's very rare that we would see that, but perhaps in entering into the home, you're committing one offense, criminal trespass or burglary, and while you're inside of that home, you're stealing and you inflict bodily injury while you're inside, or you threaten somebody with a gun. That could also be a robbery. So they're not mutually exclusive to one another. They can work hand in hand with one another. It just depends on the circumstances, really.
Gotcha. And I would guess like those situations where maybe they're charging multiple things that sort of overlap each other. That's where you get into the scenarios where maybe the DA is willing to drop one if you waive to the other, like we talked about in previous episodes.
Yep, absolutely. Now, usually a negotiation is not going to be where the most serious offense is withdrawn, unless there's, of course, an evidentiary issue that would warrant the withdrawal of that charge. Usually a negotiation would be the lesser serious offense would be withdrawn in exchange for a resolution to the more serious type offense.
Gotcha. All right. So the next category I want to talk about are sex crimes, and we're going to focus on a particular subcategory of sex crimes. But in general, can you tell us what types of criminal crimes generally fall under the heading sex crimes?
Sure. Really what we're talking about is obviously rape type offenses, sexual assault type offenses, indecent assault type offenses, those types of things we're talking about. Things where we're talking about unlawful contact with another person, that's for some sort of sexual gratification. I think that's a good, fair layman's term definition of what a sex crime offense is.
And do charges of child pornography or computer sex crimes, things like that, does that also fall under this general categorization?
It does, and certainly with child pornography, we're talking about a non-contact type of an offense. We're talking about the possession or distribution or viewing or displaying of certain images that would rise to the level of child pornography depiction. Now, that also, although it's a non-contact offense, that also would fall under the umbrella of a sex crime or sex offense.
So, talking about child pornography charges and crimes and that area for a minute here, I know you see those types of cases come across your desk, somewhat regularly. Could you first of all talk about what kind of offenses generally qualify under? Well, let's talk about it in an overview. Like we know that we've heard about registered sex offenders and Megan's Law and different things like that. Can you talk about this category and what all that means and what happens when someone is potentially charged with these types of crimes?
Sure. There's something called the Sexual Offender Registration Notification Act, what we call SORNA in short, which really means that there's certain type of sex offenses that require registration as a sex offender with the Pennsylvania State Police if you're convicted of those enumerated type of offenses. For example, child pornography. For example, rape. For example, unlawful contact with a minor. We're talking about specific type sex offenses that fall within the SORNA Act that would require somebody to register as a sex offender.
Gotcha. And is that also what sort of ties into Megan's Law?
Yeah, I think that the two are, Megan's Law is look, before Megan's Law, there was Megan. And so really what Megan's Law did was it was designed to have people that have committed these types of offenses register as a sex offender so that the policy behind it was so that other members of the community are made aware that there's a community person who's been convicted of a sex crime.
And is there a case you're familiar with? It's called the Torsorelli. Is that pronounced?
Torcellieri.
Torcellieri.
Very, very Italian name. Torcellieri was a case that came about in Chester County, Pennsylvania, probably in 2017. So it's relatively recent, I would say, still. And basically, it was a case that challenged the constitutionality of Megan's Law. And what happened was the case started at the Chester County trial court level, and on appeal, it made its way up all the way to the Pennsylvania Supreme Court, wherein the appellant, the defendant who was challenging the constitutionality of Megan's Law, was arguing that the science on which Megan's Law is based, the policy behind why we have sex offenders register is outdated. It's debunked. And if we look deeper into it, what we're saying is, why do we have sex offenders? Why do we have them register? We look to the rate of recidivism and to how frequently are these offenders recidivating, and how can we deter recidivism? And if the higher recidivism rate, we want people to be deterred from committing these types of offenses, and so we therefore have them register as sex offenders. And what the Torcellieri case challenged was the punitive aspects of having to register as a sex offender. And what it looked to is, what really is the recidivism rate for sex offenders who've maybe committed a nonviolent offense like possession of child pornography? Are those the types of people that are really going to recidivate and repeat those offenses? And if they're not, then why are we having somebody like that register as a sex offender? And if the Megan's Law statutes are punitive in nature and they're unconstitutional, then perhaps it really shouldn't apply. to the person that committed an offense like child pornography, albeit a very, very bad offense, but definitely in stark contrast to somebody who committed a violent type sex offense like rape. And so what the Torsellieri case did was it appealed the lower court's conviction and ruling that the client must register as a sex offender. And what the Pennsylvania Supreme Court case did was it agreed with Torsellieri and it remanded the case back down to the trial court so that the Commonwealth, the government, can adduce new evidence to show that the rate of recidivism currently is actually at a higher rate. And it really couldn't do that. So then the case made its way back up to the Pennsylvania Supreme Court and back down to the lower court. And it went all throughout the appellate court system until recently, earlier this year, the trial court ruled that Megan's Law is constitutional, that Megan's Law is not punitive in nature, and therefore people that are convicted of sex crimes, regardless of those crimes, must register as a sex offender under Megan's Law.
So
that's what Torsellieri did.
That's established now, that if you are convicted or plead to one of these things, that you will go on the register sex offender list.
It's always been established, right?
Yeah.
It was just that it was challenged in that one case and was litigated, back and forth throughout the system, and now it's been ruled upon, and the challenge was denied. Will that challenge arise again sometime in the future? Sure it will. Another constitutionalist will make the argument, I'm sure, and we'll see a similar type case back in litigation. I'm sure of it.
So the last category I'd like to go over with you in this episode is juvenile crimes. So I guess the first couple of questions I have for you are, what are juvenile crimes and how are these handled differently than adult crimes?
Sure. Well, juvenile crimes are any crimes that are committed by a client who is under the age of 18, who is a juvenile by definition. And the juvenile court system is vastly different than the adult court system. First of all, the language is different. We don't use terms like guilt or innocence in juvenile court. We use terms like admissions of fact or adjudications of delinquency. In juvenile court, the primary purpose is accountability and rehabilitation, and less so much of punitive. There's lesser punitive aspects in juvenile court than there are in adult court. And in short, the primary purpose in juvenile court is to make sure that the juveniles really never seen back in the criminal justice system again. So that's really the difference. I would say that the main difference between juvenile court and adult court is the purpose behind the handling of the case, the policies behind it, and also the process itself, the criminal process itself.
And so you said that a juvenile is considered to be someone under the age of 18. Is there ever times where the jurisdiction extends beyond that age?
It does. So let's say that a juvenile has committed an offense and they're what's called adjudicated delinquent, which is the equivalent of being found guilty, right? Only in juvenile court, adjudication of delinquency really means that the juvenile is in need of treatment, services, and rehabilitation. So now they are adjudicated delinquent. They're under the jurisdiction of juvenile court. A common misconception is that once the juvenile reaches 18 years of age, the case is over. That's not the law. The law allows juvenile to be under juvenile court supervision until he or she is of 21 years of age. At that point in time, the juvenile court loses its jurisdiction. So that's an important distinction that listeners should be made aware of.
Yeah. So as long as someone was charged or they were convicted or pled or whatever that final process was before they were 18, the court could maintain jurisdiction over them for 3 years past that, until they reach the age of 21. Okay. And can you explain what direct filing is?
Sure. There's certain circumstances where if a standard's met, despite the fact that the client is a juvenile, the matter could be filed in adult court. That's what we call a direct file. And usually we see that in very violent type offenses like robbery, or rape, or more serious violent type offense.
And when you mentioned adjudication of delinquency definition, is that just basically the translated versions of convictions and the likewise in adult courts?
It is. It's. I don't want to say synonymous with conviction, but it operates the same way. An adjudication of delinquency acts as a conviction on the juvenile's criminal record, and all it means is that the juvenile is in need of treatment services and rehabilitation.
Gotcha. And could you take a second and explain to us what a consent decree versus an informal adjustment is in the juvenile
Sure.
system?
Sure. So, similar to adult court, we have in juvenile court first-time offenders programs. In adult court, we have ARD. In juvenile court, we have things like consent decrees or informal adjustments. Those are programs that place a juvenile under a period of probation supervision, the completion of which allows the juvenile to earn a dismissal and an expungement of the criminal charges.
So, thanks for that overview of the juvenile system, juvenile crimes. We know there's a lot that goes into this. A couple questions here as we wrap up this episode, though. Just like adults are concerned with, having a permanent record available, how does expungement or the accessibility of juvenile records differ or match what happens in the criminal court system?
Well, I mean, the expungement laws we talked about in one of the earlier episodes, the expungement laws for juveniles are very broad. They only under in very, very limited circumstances can a juvenile not petition the court for an expungement, and those are usually with sex offenses. Um, so usually what we see in juvenile court is a district attorney oftentimes will agree, depending on the facts of the case. Oftentimes, we'll see an agreement that after a certain period of time, after completion of probation supervision, the district attorney's office will agree or consent to an expungement. Because again, the purpose behind juvenile court is to rehabilitate. We don't want there to be too much emphasis on the punitive aspects of a juvenile committing a crime, and we really don't want to see the juvenile back in the system again. And so that's why the expungement statutes are broader than in the adult expungement statutes, and also why the district attorney's office is more willing to kind of work out an agreement to an expungement.
And it sounds like the juvenile court has sort of their own set of rules. It's obviously, has a different standard that it's applying to the participants that come through it. So, with all those things in place, is it important to consider hiring an attorney early in this stage? And do people need to be looking at an attorney who understands this system, given that it has such differences in how things are applied?
Yeah, I mean, you want a criminal defense attorney who understands how the juvenile court system works. Like I said, it is a foreign language, and the juvenile court system has its own rules. So you could be a criminal defense attorney and have a law degree all you want, but if you really don't do juvenile work and you're really not familiar with how the juvenile rules work, you're not going to be doing your client any justice by helping by learning how to navigate as you're going through that client's case. You have to have familiarity prior to getting involved. And the best way to do that is to observe and to ask questions. So when the parents are looking to secure counsel, they want to make sure that the counsel that they're choosing really has a knowledge and familiarity with how the juvenile court process works.
And is it important for them to, if they're going to consider hiring an attorney, make that decision earlier than later? I would guess that, the way things go can be influenced by, communication between counsel who understands the system and navigate that a little bit better or in an easier way path forward for everyone if you're involved from the offset.
Sure, absolutely. It's always best to have an attorney present from the outset of a case, of an investigation, but particularly important when we're dealing with juvenile cases.
Well, Paul, I appreciate your time. We only touched on a few of the types of crimes that you defend clients on, and don't want to give our listeners out there the impression that this is by any way an exhaustive list. But in the interest of time, we wanted to hit some of the big ones that you see regularly. But I would imagine that if anybody has a question, regardless of the crime that they might be facing out there, that they should be reaching out to you to get your input and opinion on that. Definitely want to thank you for your time and providing your guidance and your expertise in all these areas and helping us put this podcast together. So appreciate you.
Absolutely.
And
Thank you.
we'll talk again soon.
All right. Thank you very much.